Before we call the case, as soon as the truck goes by outside, I want to say we're well aware that sometimes technology works wonderfully well and sometimes it has its flaws. And if we have any problem on anybody's point of view, we'll pause and work through and solve it. Mr. Hivner and the IT people from the AOL have done marvelous jobs in dragging us into the 21st century and setting it up so the technology is working very, very well so far. But if we should have a problem, we understand it. It won't be any, we'll just correct it and move on from there. Mr. Hivner, if you would, please call the case.
Michael Surber versus Mountain States Health Alliance.
We'll hear from the appellate.
May it please the court, I'm Mark Hurt representing Michael Surber. I request 5 minutes rebuttal time.
That'll be fine.
I'd first like to give a brief introduction of the case. This appeal involves a claim of institutional negligence against the hospital. This type of claim was recognized by the Tennessee Supreme Court in Barkus versus River Park Hospital. The claim was dismissed and did not go to the jury because the circuit court excluded the testimony of plaintiff's expert on standard of care and breach of that standard. The expert was a hospital administrator, and he proffered testimony that the hospital violated the standard of care by failing to enforce the hospital's rule that every ER patient must be seen by a physician. In fact, the expert was Dr. Markowitz, who was also the expert in both our case and Barkus. And he also attempted in our case to give essentially the same testimony as he gave in Barkus. The circuit court erred as a matter of law in its ruling because both of the court's reasons for excluding the testimony are completely at odds with the Barkus decision. The court's first reason for excluding the testimony was its content. The court said that the expert could not equate a violation of a rule of the hospital with a breach in the standard of care. This is clearly contrary to Barkus, as Barkus says, quote, "A hospital can be negligent for failing to enforce its policies and procedures," unquote. Barkus also says that, quote, "The failure of River Park," which was the hospital in Barkus, "to follow its own written policy was evidence of River Park's breach of its duty to provide reasonable care," unquote. So the court's first reason is clear error, and the ruling should be reversed for that reason. The court's second reason for excluding the testimony was that only a medical doctor could give expert testimony on breach of the standard of care. This rationale is also contrary to Barkus for two reasons. First, the circuit court failed to understand that the breach of care was, as Barkus teaches, an administrative failure, not a medical one. Second, Barkus cited Dr. Markowitz's testimony with approval. A medical license should not be a requirement to testify on standard of care and breach of care in this situation because, as Barkus points out, the breach of care was, quote, "an institutional failure that was in essence managerial and administrative in nature," unquote. It is not a failure of a physician or other healthcare provider to provide adequate care. It is a failure of the hospital itself and its administrators, who are peers of Dr. Markowitz, who also administered hospitals. As Barkus also states, the hospital must administer and oversee the activities of the emergency room department. And, quote, "the administration of the hospital is also responsible for implementing an effective system of oversight to enforce its policies," unquote. In fact, Barkus upheld the finding of negligence by the hospital, even though there was no finding of negligence by any of the individual healthcare providers. And Barkus made this, reinforced this point in its opinion on the rehearing.
So let me ask you the question here. The failure of care would that equate, would the hospital rules equate to that? Or is the failure of care? The failure to provide, for the patient to see a physician?
Yes, so the rule, when in fact, Marcus said basically that Dr. Markowitz testified that the failure to enforce the rule was a breach, or that was the standard of care. And they said it was commensurate with the actual policy of the hospital. So they were one and the same.
Okay, if they're one and the same, does that mean that any patient appearing at the hospital must be seen by a physician? That would be the standard of care for any patient?
Yes, that was the rule. That was the hospital's,
regardless of what the injury or the ailment may be?
in the emergency room. Yes, that was the hospital's own rule. And I don't think there's any dispute that that was what the rule was, both for the hospital in Barkus and our hospital. The rule was essentially the same. And so this does not mean that the doctor would need to do all the treatment, but the patient would need to actually be seen at some point in the process by a physician. And that was clear in Barkus, and also the plain reading the rule in our case. They're essentially the same rule.
What did your physician testify to? Did the physician testify to the standard of care?
No, this is our standard of care was not what the doctor would do with the patient, but simply that the hospital itself, the emergency room itself, had to enforce the rule that each patient be seen by a doctor. So the negligence was institutional in not enforcing the rule that every patient be seen by a doctor. And so in our case and in the other case, the patient was seen by a healthcare provider that did not have the qualifications of a doctor.
What was the testimony regarding the actual failure to provide that standard of care versus as to the injury itself? Okay,
so the rule was breached. They weren't enforcing the rule. I think maybe you're getting to the causation. Did that cause harm, the failure to enforce the rule? And we had an ophthalmologist that was designated to speak on that issue, causation. But
is that testimony in the record?
That testimony, what happened was Dr. Markowitz, his testimony was excluded. Then that basically was fatal to the claim. So what we did was we put in the disclosure of what Dr. Edmonds, the medical doctor, would have testified to had the claim been allowed to go forward. And that's the official disclosures that we gave to the other side months or years earlier, that they had the official disclosure that was required for all the opinions that would be submitted to the court, submitted in testimony. So it was Dr. Edmonds said, basically his opinion was, and he was ready to testify at trial on that if the claim had not been terminated, in effect, was that if the patient had been seen by a physician and evaluated, that the harm of him being turned away or discharged without treatment would not have happened, that the physician would have treated him adequately.
Now, tell me why that evidence was not presented.
Because when Dr. Markowitz testified, he testified first. The court did not allow any of that testimony. That testimony was essential to the direct liability claim. So that was a fatal blow to the claim, in effect terminating the claim. Any other evidence on direct liability would have been inadmissible and could not have been shown to the jury. So we went ahead and put in the record what his opinion was and what he would have testified had the claim not already, in effect, been terminated.
Okay, thank you.
Counsel, I'm still a little confused. Is it your position that the policies, the rules and procedures, the policies of the hospital establish the standard of care? And that's all you have to look at?
No. As Marcus pointed out, they found that, that a violation of the policy could be a violation of standard of care, but they pointed out that you need expert testimony. In addition to just showing the violation of the rule, you need expert testimony along with that. And that was the footnote. And what's very interesting, Your Honor, in that footnote was when they made that point that you need expert testimony for both standard of care and breach of care in this situation, they footnoted Dr. Markowitz's expertise as an administrator. So if you look at footnote 2 and look where they put the footnote reference, it's right at Dr. Markowitz.
So you put in an offer of proof as to Dr. Markowitz, correct?
Yes, Your Honor.
Did he say that the policies of the hospital were commensurate with the standard of care?
In effect, he did. He said that the breach of those was a breach in the standard of care. He equated those. But
what I'm trying to figure out is, did he say, I mean, in your time's up, but don't worry about it. In Barkus, Supreme Court talked about it's commensurate.
Mm-hmm.
The policies there were commensurate with the standard of care.
Yes.
Didn't say that the policies established the standard of care. So did Dr. Markowitz in the offer of proof say that here the policies were commensurate with the standard of care?
He tested, well, I asked him if that was the standard of care, and he said yes. I think if you go through and look at his entire offer of proof, that he shows that there was a breach of care there and that was the standard of care, because the question was about if you look at the question, it's about standard of care and breach of the care. And then he answered it, yes, that was the case.
All right. You have time for.
Was any of his testimony presented to the jury? Was any of his testimony actually in the record presented to the jury?
He started testifying, but then when we started getting into the standard of care and breach of care, there was an objection. And the court granted the objection to exclude the testimony. And then we presented the question and answer in the offer of proof.
Okay, thank you.
You have your 5 minutes for rebuttal. We'll hear from the appellate now.
Good afternoon. I'm Jimmy Miller, member of the Kingsport Bar, and as Mr. Hivner noted, co-counsel Attorney Anderson from Washington County is present and counsel for the hospital too. I guess a couple of things, maybe just to get to the heart of it. And I think the question is, did Judge Lauterbach abuse his discretion in limiting the testimony of Dr. Markowitz? Judge Lauterbach did not exclude Dr. Markowitz from testifying. If you read the transcript, ultimately that's a call that counsel for the plaintiff made. But what Judge Lauterbach held, and he held this in advance of the trial, that Dr. Markowitz could not simply say, this is what the policy says, and that's the standard of care. He required him, and so in essence, to Judge Sweeney or Judge Clarity's question, it wasn't, he said, you can't simply say, if this is in writing and it's part of the hospital's bylaws or rules or regulations, that's the standard of care. That's what Judge Lauterbach ruled in advance of the trial. And at trial, if you look at the very first question after, in front of the jury, after you move past his, you know, the introduction of him, the very first question that he is asked is to talk about the policies and procedures and about the hospital's role in caring for a patient. And so for 3 pages, without interruption, Dr. Markowitz answers, and his answer is essentially, here's the rule and regulation, the medical staff adopted it, the board adopted it, that's the standard of care. And, you know, for 3 pages, we didn't object, but we finally objected and, you know, thinking he was going to add to it. So then there's a long, Dr. Markowitz is asked to step out of the courtroom. There's a discussion about what had previously been put in writing, that he could not equate the standard of care. You know, he couldn't prove his standard of care just by saying, this is the policy, this is the rule or regulation. And he did exactly what the court said he couldn't do. I think that plaintiff would have you believe that BARCS stands for the proposition that if something's in a rule or a reg or a policy, that is the standard of care. And I think that goes too far. You know, the court, I'm sure, is familiar with that decision. I think it's important to take note of the context of that decision. You know, what the Supreme Court in that case had to decide was there sufficient evidence to warrant a verdict against the hospital, and no other, I'm not sure there were any defendant, there were no other defendants, but they didn't find comparative fault against the people that were not defendants. And in that case, you know, they do all the things that you do when you're deciding the sufficiency, the weight of the evidence. They looked at everything in favor of the plaintiff. They disregarded all the testimony to the contrary. They assumed all the truth, or assumed the truth of all the evidence in favor of the plaintiff. And lastly, they drew whatever reasonable inferences, considered whatever reasonable inferences could be drawn. But this case is not BARCS. And the reason, the difference is that in this case, Dr. Markowitz was the only witness that the plaintiff had to carry the burden of proof. What the Supreme Court noted in their decision was that there were 3 witnesses: the ER doctor, the cardiologist, and Dr. Markowitz. The court also noted, and you know, again, you probably know this, I think the record reflects that because Markowitz was the only witness, that somehow, you know, his role in BARCS has taken on a larger role than he really had. I mean, if you read the decision, Dr. Markowitz is mentioned 1 time. In candor, he is referred to 1 other time, but it's all 3 defendants, and that's the language that begins at the bottom of page 832, top of 831, 832, that, you know, under that it was all 3 who said what the standard of care was, and they all 3 said it was a breach of the standard of care. It melts the witnesses together. It's, you know, maybe I'll just read. At trial, presented the testimony of the hospital administrator, and that's where he does that naming, with 29 years of experience at various Middle Tennessee hospitals, a board certified emergency physician, and a cardiologist, all of whom testified that the treatment of Dr. BARCS in the emergency room fell below the applicable standard of reasonable care for the hospital under the circumstances. And they agreed that the failure to follow its own written policy requiring a physician see the patient was evidence of a breach of the care. Contrast that with our case. In our case, the plaintiff's own witness, who was not a doctor, but it was the only standard of care witness, is a physician assistant named Hobson Bryant. And Hobson Bryant testified that he saw he practices in Greensboro, North Carolina. So he likened the hospitals where he practiced to Johnson City, similar community. And that he sees patients without them ever being seen by a physician, that he sees patients without ever consulting a physician, and that it is up to him as the physician assistant to decide, do I need to go speak to the physician about this patient? You know, they're there just like they were in this case to come and see the patient if requested. But it is healthcare as we know it back in 2006 and in 2020. You don't always see a physician. And he said that's what he did. And the standard of care in Greensboro was like the standard of care in Johnson City. Now, he was very carefully never asked by the plaintiff's lawyer, what do you think about the fact that the plaintiff, the patient, was not seen by a doctor? That question was never asked. And again, because this case has been going on so long, we used the discovery depositions taken before the case was non-suited the first time. And so in that deposition, we asked, do you see patients on your own? Do you see patients without ever consulting a physician before the patient leaves the ED? And he said yes. And so that's what we asked him at trial. And he acknowledged in this case, just like in Greensboro, doctors sign off on their records. They may not do it while the patient's there. They may not even do it the same day, but that was his testimony. And then you had 2 ER doctors that testified for the hospital. We used to be a 2 health system group in the Northeast Tennessee, Wellmont and Mountain States. These 2 doctors were essentially, at the time, not employed, not affiliated with Ballad. And they both testified, and if you even read the regulation that we're talking about, it talks about unattached patients, meaning, and Dr. Wilkinson in his testimony explained that's written back when doctors would come and see their own patients in the emergency room. Anyway, but they testified, no, it is not the standard of care for physicians to have to see every patient that comes in. And we do use nurse practitioners and PAs, mid-level providers. So, and then you had Mark Ingram, a PA, who's worked in the team health system in the Knoxville area and other places, Morristown. And he said, in our hospitals, PAs, nurse practitioners see patients without being seen by a physician. So you have essentially 5 witnesses who say that's not the standard of care. And you have Dr. Markowitz say, I'm sorry.
I mean, it was a directed verdict that closed the plaintiff's proof.
Yes, sir.
Where did these witnesses, these are your witnesses you're talking about?
So the one I was talking about from Greensboro was plaintiff's witness.
Okay. Anybody else's?
The other 4 were called by the defense.
You did call, but no, I'm sorry. I thought it was a directed verdict at the close of plaintiff's proof.
So there were 2 issues. The hospital was being sued for the vicarious liability of the PA.
Yes.
And the hospital's
right. Direct liability.
Right. And so the directed verdict just went to the direct liability. That's right.
All right. So when they testified, the hospital was already out.
They were out on the direct liability.
Out on the directed verdict.
That's right. The hospital at trial, even when the case was refiled in 2014, the hospital was always the only defendant. And I want to speak to the causation. And
help me. I'm confused again. It doesn't take much
Okay.
to confuse me. At the trial, when this case was trialed, when it's up on appeal now,
right.
who were the defendants? Anybody else other than the hospital at the time of trial?
No, sir, just the hospital.
All right. So when the trial court granted the directed verdict as to the hospital at the close of the hospital's proof in this trial, none of your witnesses have testified.
So what the judge did is he granted a directed verdict on the direct liability, this notion that they had, every patient had to be seen by a doctor. They still had to put forward proof that because the plaintiff sued the PA for, or didn't sue the PA, but sued the hospital and claimed that the hospital was vicariously liable for the PA.
All right, I understand. That was my mistake then.
Well, I should have said that, made that more clear. But I do want to talk a little bit about the causation. Dr. Edmonds, so it took us all day to pick the jury and make opening statement. And so on the second day of trial, for the entire morning, the plaintiff played 2 videotapes. And then we got ready to take the lunch break and the judge said, be back at 1:15. And the plaintiff said, can we come back at 1? I've got a witness that needs to catch a flight. And the judge said, sure, we'll be back at 1. And so the plaintiff puts on Dr. Markowitz, and his testimony was shortened because in the midst of that, at some point, and again, if you read the transcript, the judge didn't say Dr. Markowitz can't testify. He just said, I told you he can't say, about the policy being the standard of care. So we finished that up, and then Dr. Edmonds testifies, and he testifies only as to causation. He says on cross-examination, I'm only offering testimony about the causation. And he prefaced all of his causation testimony on the accuracy, the correctness of the PA witness that the plaintiff put on. So he also testified that the plaintiff, in his view, the plaintiff's eyesight was salvageable up until 3 weeks after the plaintiff was seen in the emergency department. So that was his testimony. And then the offer of proof says, had a physician seen and properly evaluated Surber, and then he goes on to say, it would have made a difference. And the fallacy of that offer of proof, well, first of all, we did not have the opportunity to question him about that. And now I'm out of time.
Go ahead, finish your thought.
Okay, so we didn't get to question and answer, have that. And the plaintiff knew that because the judge made that an important part when he was making the offer of proof. He said, they're entitled to ask questions. And so Dr. Edmonds, goes home that night. And then the next morning we get this for the, written up, here's his offer of proof. And so we think Judge Lauterbach thought long and hard about this. He took a long time in reaching the motion in limine decision. He did not exclude Dr. Markowitz. He limited his testimony, and obviously we'd ask the court to affirm that decision.
Thank you. We'll hear from the appellate and rebuttal.
I'd like to go back to your question about where in the testimony I'm sorry, Your Honor, I don't see you. I see Ms. Miller. Okay. I'd like to go back to the question of where it was in the transcript about Dr. Markowitz and his testimony in the proffer, and it starts at the bottom of page 77. And I'd make it clear, Dr. Markowitz, what are your opinions on the standard of care, applicable standard of care, and breach of care? And he answers in that context. He doesn't parrot back the standard of care is, but he's responding to the standard of care and the breach of the standard of care. And in that, he says they did not follow and enforce this rule, just like he did in the Barkus case. And they were obligated to do so. So I think this tracks Barkus very well. There's no real distinction on this issue. He does equate the standard of care with the requirement to follow the hospital's own rules. And that's exactly what Barkus goes over and over again. The failure to follow their own rules can be negligence. I also like to make the point that Ms. Miller is confusing the vicarious liability proof with the direct liability proof. Totally separate. Mr. Hobson Bryant did not have anything to do with the direct liability claim. In fact, the Supreme Court emphasized again in the rehearing that that there's a big distinction there, and the individual healthcare providers can all do proper care, yet the hospital itself can still be liable for negligence because they didn't enforce the rules. As far as the offer of proof, the defendants cite no authority that we actually had to put on Dr. Edmonds for a question and answer. In fact, they only cite Rule 103, and Rule 103 limits its discussion of offer of proof and the question and answer to the evidence that the judge has excluded. It doesn't mention anything about having to put on other witnesses for offers of proof just to show that that's not a harmless error. And so there's no authority that they've offered to suggest that we had to do that. And in fact, oftentimes offers of proof are simply things other than question and answer. We had Dr. Edmonds' disclosures of his opinion, and his opinion at the end of the disclosure is a standalone opinion for the direct liability claim. And if you look at that paragraph that we've quoted, that is an adequate opinion to take the case to the jury. And we cited that. The hospital cited no contrary authority on that. So if you look at what Judge Lauterbach actually said, the comments justifying his exclusion of the testimony are directly contrary to Barkus. He's saying that you cannot equate the hospital's internal rules with the standard of care. Barkus says exactly the opposite. And he says you cannot base a breach of the standard of care on the failure to enforce and follow those rules. Barkus says the complete opposite. So I would say that this case does track Barkus, and there's no real determinative differences between Barkus and this case. And if you look at the testimony of Dr. Markowitz in context with all the questions and answers on the standard of care and breach of care, he is saying essentially the exact same thing he said in Barkus.
All right. Thanks to counsel for both sides. We appreciate your arguments and your briefs. I think we certainly understand what the issues are. Mr. Hibner, if you would, recess court until 2:30, please.
This honorable